What is not really public record, but the council knows, are an appendix that I put together. And that consisted of 2 council meetings preceding the issuance of citations, verbatim, the 2 listening sessions. So they were all presented to the court and given to the defense counsel. All the police reports, all the good, the bad, all the detail, all the opportunities to make arguments against the citations had they ever come to trial. I said at the last meeting that I was present that we are an open book, and we have been, and all should know that. Now, I also want to say that every time any attorney asks for a courtesy of an extension of time, that they be allowed to set aside a default that the clerk entered, because the city never entered any defaults on these cases, so that people could answer the citation and request a formal hearing. I consented to all of those without exception. This case dealt with primarily 2 Supreme Court decisions. I'll just mention them in passing. One's a 1941 case that said local bodies have the right to regulate their roadways, providing that it's a content neutral regulation, as against any First Amendment right or action such as a religious activity, which was the case in the Cox case. That's been held consistent forever. There's also this case called Gilbert or Reed versus the city of Gilbert, Arizona. It's a sign regulation case, but it does stand for the proposition that commercial speech is subject to the same benefit that any political speech would be, that there can't be 2 standards. This case, it just surrounds a 2017 amendment by the Michigan State Legislature to the state statute about obstruction of traffic. It's really, the way it was decided by the judge, got really nothing to do with the city of Chelsea, save for one fact, and I'll get to that. And I want to say, at the beginning here, I am extremely dissatisfied, and I'll explain that to you, with the decision of the judge. I respect her. I think there were other ways she could have come to the results she did. But what she has done is create a larger problem than she was presented. The judge, further in her decision, and I take it from the comments here that most everybody's listened to that, I've ordered a verbatim written transcript so we could have that. I don't have it as of tonight. The decision was made on February 22. I don't expect that the court's going to enter any other order. The opinion given is effective as of the date she did that. The time for appeal is 21 days. I think everybody can calculate and can figure out that's 2 weeks from tonight. So if the city council is not going to authorize an appeal, and you have to, because I can't act alone at this point. Last time I was here, I told you I was appearing in response to a motion that was filed and a request for formal hearings on citations. This office didn't authorize any of these, but frankly, I saw nothing amiss in the way the citations were written. All right, so this comes down to 2 circumstances. A person standing in a roadway for the purpose of soliciting contributions, and people who block, interfere, and obstruct the normal flow of traffic. I said then, I say now, that this is not a question of free speech. This is a question of conduct. And the court took its time and accepted the premise, basically, that we were making, that there can't be an absurd result here. It's got to be consistent. But what the court did do, she said she was going to apply what we know as a standard of strict scrutiny. That if there was a possibility, rationally, that there be circumstances which would lead to a denial of rights, that the whole statute had to fall. What the judge did was also ignore a statute that's on the books forever, saying that pedestrians have the right to walk in the untraveled portions of a roadway. Roadway is defined as 66 feet wide, and we do that every day. The other points is that the court could have had a trial. Court could have found lack of intent by individuals to obstruct traffic. It could have found that the officers did act arbitrarily. It could have found that the methods of suspended the fines. After all, what is a citation? Citation carries a civil penalty of an amount of money. And purpose of a citation is to encourage people to comply with the law. The statute under which these citations were written has been declared. I want to say this. This is not a city ordinance. This is not an enactment of the city council. This is an enactment of the Michigan legislature that she specifically held to be unconstitutional, unenforceable in any circumstance, basically. The court could have, as I said, found that the officers violated any number of facts. So those who say that this is a criticism of the police, I think that may be true to the people who say that, but it wasn't something that the court found. The court did say, and I agree with the court, and I think we all do, that the citations were issued while there was a protest. That's given. So what's the legal effect? If there's no appeal, then this is the law of these cases. People can decide what they want to do with what happened any way they want to. In one sense, it's unlikely that anybody would be successful given the burdens of proof, but they could sue for any amount of money they wanted to. They could sue for anything they wanted to. There is also the question of what next? What is the effect of this decision that the Michigan State Legislature made a mistake in writing its language? Judge Frushour sits in Washtenaw County. She's one of the district court judges in the 14th district. I assume that she will follow what she said in this case and all other cases where somebody is similarly situated. That is, they're protesting. They're exercising their rights under the Constitution to protest their political views, social views, the right to assemble, their religious right to proclaim their faith. Now, I would assume also that this would apply to anybody coming through this town with a Confederate flag on the back of their pickup, as sadly we have seen over the years. From places not originating from places which aren't even in this city. We're dealing with M52. There are 12,000 vehicles a day. That's roughly 30,000 people traveling through this city. Very few stop. I think that it was maybe 10 years ago, City Council commissioned an economic development study, and at that time found that 10% of the people coming through the city were stopping. Just based upon my comment, just my observation, I'm sure it's less than that. So what does this police department, what do police officers do if there are protests other than the ones we've seen today? Can they threaten those individuals with a citation and an economic sanction to get them out of the highway, to release the traffic that is obstructed, to grant to everybody who wants to use the road the right to their safe and normal passage of their vehicles? And how do you stop? How do you control the necessity of the police, whether you like them or not, to come out and regulate traffic? I really don't know. Now, Chelsea can be viewed, as a result of this decision, as an exception in the enforcement of the motor vehicle code. I don't know if this decision is going to have any impact upon other jurisdictions, but that's going to be the sheriff's department and other police agencies who bring those cases before the court. I think this is probably beyond my function, but as a citizen, I can also see what's going on. Why did these protests take place? Well, in part, it took place because Maya King was assaulted here in Chelsea. And I would remind everyone that Chelsea Police Department did a full investigation of that charge, sat in Ann Arbor at the Washtenaw County Prosecutor's Office until there was an election and there was a new prosecutor. And then the matter was authorized. So, if there is not a civil infraction penalty for blocking traffic, what is there? And I've looked at the statute and I've talked to some of the officers about this. And the only civil infraction penalty happens to be the obstruction of traffic. After that, the tools that the police officers will be able to use to restore traffic or to separate people or to control the situation all rise up to the level of arrest and for breach of the peace. I want to recommend that the council authorize an appeal of this case just so that we can get this matter back to where it belongs, that the court make decisions on the facts and circumstances that come before this. There was one comment made here by one of the members of the public about the abilities of a law student. That law student, I agreed, could file further authorities with the court with respect to the question of what should have been done had the court decided to sever the bad portion of the statute from the good. And she quite correctly pointed to 3 federal court decisions which have come up in similar cases, and but that would be this. It would be that the court would say that the citations could go forward and that the part of the statute that was added in 2017, but tickets would still be dismissed and that they'd have to be written again as a result of new infractions. I did not respond to that, and I knew what I was doing when I did it. So it's not that we've had a conflict here. We've tried to keep this argument, position of the city, that this is a question of conduct of people in the traveled portions of the roadway. It has nothing to do with speech. And contrary to what has been said tonight, it still has got nothing to do with speech, no matter how laudable are the objects or the intention of the people. I don't think that this decision of Judge Frushour most respectfully moves the ball forward at all. In fact, it presents some real problems. I'll take questions.
All right, thank you, Mr. Flintoff. I'll start with council questions. Ms. Albertson, please.
So, Mr. Flintoff, have you this evening, have you articulated all of the problems that you've identified, or just some of the major ones?
I think just the major ones. I can't anticipate what may occur or how it'll arise.
All right, thank you. Mr. Feeney?
Yeah, thank you, Madam Mayor. So question, Councilor, how broadly binding is the decision? Is it just in the district, or because it was referencing a state statute, does it have implications beyond the borders of the 14th district?
It doesn't have implications. Well, first of all, I don't know that, but it could have implications beyond the 14th district. There's no one else who can really challenge it other than the city of Chelsea. And it certainly is binding on here. It's like we're a hole in a donut. Now, what any other judge would do with this question, I don't know. But Judge Frushour is a good judge. She's consistent. And if this is her view of this statute, I suspect it would be her view of the statute in similar circumstances. She said strict scrutiny, which means to me that anybody who's similarly situated to these protesters and who are protesting without advance notice, or and somebody makes a decision that they are in fact impeding the normal course of traffic, that a citation, if issued, would be thrown out. And I think the impact of that happening again and again presents additional problems of maintaining communication, shall we say. And it just goes on, and one group can challenge the city after another group finishes. Does not bode well, in my opinion, in my experience, for whatever it's worth.
All right, thank you. Mr. Wiseley?
More of a statement. Yeah, my concern all along has been the safety of the people walking down the middle of the road. And as someone who has held the hand of a man who died in the street due to a distracted driver, I don't want to see that happen to a 14-year-old because somebody was adjusting their radio. All right, it's nice to have the argument, but reality is people get hurt, and that's not something you forget ever. Thank you.
Ms. Albertson?
So, Mr. Flintoff, I just want to be understood here. When I ask these questions, I'm not necessarily advocating a position, I'm just seeking information. Okay, so if the city were to do some sort of appeal of the dismissal of these sorts of civil infractions, and if the city were to decide to appeal that, I don't know if I just repeated myself, but is there any way that something like that could be done without I mean, it would be restoration of those charges, wouldn't it? Of those not charges, but civil infractions, right? It'd be reinstating them, or would they be, since they have been dismissed, would they remain dismissed? And we would then be appealing the judge's decision only.
Appealing the judge's decision only, but the cases would be reinstated, and it's to the extent that they would go back to the same judge and she could find something else wrong with the charges and dismiss them on some other ground, or try them, or find people responsible. She could suspend a fine. There's nothing, none of this money goes to the city, as I.
Right.
All right, Mr. Flintoff, just want to make sure everyone's clear. Right now, we have a decision which dismissed a case based on constitutional grounds that leaves the city without a civil infraction option for enforcement. Should we have an issue with public safety in the future, the city's only legal response that they have available at this point is a misdemeanor, unless A, the city appeals the decision on a legal matter, or B, the city could also ask the legislature to amend. I see the response, but we could seek an amendment of the statute to eliminate the prior 2017 amendment, which is what caused the issue for Judge Frushour in her ruling. Correct? Did I summarize that correctly?
You got it.
Okay. All right, thank you, Mr. Feeney.
So my question is, if the Proud Boys or the Klan decides that they want to use Chelsea as their marching place, which none of us would welcome, do we have an enforcement option if they don't pull a permit and they block M52?
Well, based on those facts, I don't see what's wrong with that constitutional. They would have, if they want to exercise their First Amendment rights, it has to be judged at that time. But you could issue citations for the same, under the same statute, send them up. But I would think that the attorneys representing the Klan would make the same argument before Judge Frushour and cite to her the decision in this case. I would expect the same result. Dismissed.
All right, thank you. Ms. Albertson?
So this is this agenda item is discussion only. I think that we need more than just discussion only after this evening. I think we need to really hash this out and think about it and decide, is there something more that we should do that would, actually I'm going to use the word protect the city, because this is exactly, Mayor Johnson, what you had anticipated, that this would be the thing that would occur. And we're now out on that wobbly limb that I mentioned. But I think that we need to come together as a council and find some direction amongst ourselves on what to do about this.
All right, Mr. Wiseley?
I'd like to speak to Mr. Feeney's point, because that's a point that's been made month after month, time after time. We've discussed it time and time again, and it's evident that a lot of people out there just don't care who comes and marches down our streets.
All right, thank you. Ms. Pacheco?
Thank you. I have a question for Mr. Flintoff regarding protected speech. I guess the question I have is in reference to Councilmember Feeney's, anecdote. If the Proud Boys or the Klan march on the streets and civil infractions were given and the attorneys came up through the court system, what sort of, I guess, criteria or what's the process for protection of hate speech, and how would the court look at that in particular?
The real answer to the question is I don't know. And because all I can tell you is these concepts were not discussed in this case. They certainly weren't discussed by Judge Frushour. She did not use any of those expressions.
Thank you. I think that there are certainly case law that deal with those types of speeches, and that's something that can certainly be researched and provided. But one of the things we've talked about, correct, Mr. Flintoff, is city cannot engage in viewpoint discrimination. Is that correct?
My understanding, yes.
Yeah. All right. Thank you. Ms. Claus?
Thank you, Mayor Johnson. Question for Mr. Flintoff. You had mentioned that in an appeal, you'd want to get this back to addressing conduct and not speech. Was that right?
Well, then the judge discussed conduct. And if you listen to what she said the Michigan State Legislature made a mistake because they allowed conduct of standing in a roadway, in that she said that there were health and safety concerns there, and it was inconsistent, therefore was inextricably intertwined with conduct of obstruction. And then she threw it a haul out. And it could have been divided. And it isn't. And this is so I think it's a problem.
All right. Thank you. Any other questions at this point for Mr. Flintoff? Certainly, there's no decision making tonight, but we want to make sure everyone has an opportunity for counsel to ask questions. All right, I don't see any other counsel questions at this time. Mr. Flintoff, is there anything else you want to add?
No.
Okay. All right, thank you very much. Ms. Albertson, I'm sorry, you had your hand up. Is that just not putting back down?
No, it was a new raise.
Oh, I'm sorry.
No, that's quite all right. I put up, you wouldn't have caught it. That's okay. So I guess I'm left with a lot of confusion, and I think that we're not done with this. And I guess I need to know how we're going to go forward with getting some closure to this. Any ideas? Does anybody have any ideas?
Mr. Flintoff, did you want to answer that, or Mr. Hanifan, do you want to talk about next steps?
I've said what I think I need to say.
Mr. Hanifan, did you have anything to add?
No, I don't.
Okay, thank you. It's not for a decision at this time. Certainly, we haven't received an order. Mr. Flintoff, the date you said is 2 weeks from today? I'm sorry, you're muted.
I'm used to being in courts where I forget to mute. That's correct. I think the 21 days will have run by this hour.
Right.
15th of March. The Ides of March, by the way.
Okay. All right. Thank you. And Ms. Quaz.
Thank you, Madam Mayor. Just in the topic of just being a discussion and not suggesting anything, but maybe you could answer, is our only option then if the next council meeting would be too late, would this merit a special meeting, or would a special meeting be an option called before our next council meeting?
That certainly could be an option if council members decided they wanted to do that. There is either, I believe it's in the charter, explains how to do that if a special meeting's warranted. I think certainly one of the challenges right now, certainly no decisions could be made tonight. There is no written order. Is that correct, Mr. Flinoff? And I don't believe she was going to issue one, correct?
That's our understanding.
So there's no written order and there's no transcript at this time. So there's certainly no good basis to make any decision at this time in terms of if council wanted to review further or more in depth what the ruling was and what their options were. So that's a long way to say, yes, council could call a meeting should it choose to do so. All right, just again, so everyone's clear, just to summarize it, our city's options would be to do nothing, authorize an appeal for the legal issues at play, or as I mentioned, petition the legislature to change the law, change the statute. All right. And that then, I don't see any more council member hands on that, so we'll proceed on to item number 2, which is revisions of council rules and city board, committee, and commission handbook.